they have beat it into him, if it wasn't already done, that Kristen is no longer a part of your life. Even with the report of his income tax being sent over to the house and then somebody else cashing it, that was upsetting to him. I said, contact the police, make a report, and the IRS is investigating that, and he has just let it go. So he has been making better decisions, and I think once he gets a good job, gets back on his feet as best he can, that we won't have any other issues with him, and he knows to stay away from her, even after December of 2025, because she is no longer part of his life and she does not want to be. I've stressed that to him, his father has stressed that to him, and he's acknowledged that, and I think it's in his head now that he has moved on beyond this, Your Honor. Thank you.
Thank you. Mr. Henley, what do you want to tell me?
I'm very sorry, Your Honor, that this happened. I'm sorry I made those stupid mistakes. They definitely will not happen again. Everything that Mr. Deebs has just said is all currently true. And, I'm just trying to move on with my life and have a better life. And, that's really, like I say, it will not happen ever again.
Why did it happen?
I was trying to get my dog back, actually, and like I said, I did try to call the clerk's office, and like I said, they said.
Did you get a copy of the order?
I did. I did.
Did you read the order?
Yes, I did, Your Honor.
Then if you read the order and it gave you a date certain and what your obligations were, why did you call the clerk's office?
Because I had ran into somebody that was one of her friends, said she wants to give you your dog back, and I said, I didn't want nothing to do with it. A week had gone by, and I said, well, because she had told me she dropped the protection order. That's why I made the call to the clerk's office. And like I said, but I should have came here, made definitive, not just went off over the phone. It was my mistake. And like I said,
What's been your fascination with this girl that you keep bothering?
It really, Your Honor, was not the girl. I was trying just to get my dog back. That really.
Why did you bring flowers to her?
Just a peace offering. That was it when I went there.
Okay.
Before this hearing even gets uncomfortable, let's be very clear about what we're dealing with. This is not a misunderstanding. This is not confusion. This is not someone almost following the rules. This is a grown man who was explicitly told to stay away, in writing, in court, and with consequences, and decided that the rules somehow didn't apply to him. All sounds. The defendant speaks calmly. He sounds reasonable. He uses all the right words: remorse, growth, moving on, but none of it matches his behavior. And that disconnect is exactly what courts look for. Because stalking cases aren't about one moment. They're about patterns. Repeated choices. Repeated boundary crossings. That you're also going to see a defense strategy that collapses in real time, minimizing
Relationship with her anymore.
Yes, you did, because you couldn't understand why you were living there and all of a sudden you were not unwelcome, right?
No, when she asked me to leave, I had left and got my own place to live.
Okay, then why do you keep getting protection orders against you? Why do you keep running in and out of Painesville Municipal Court in the last few years?
Well, those were very stupid mistakes that will not happen again, Your Honor.
Yeah, but that kind of goes against what you're telling me, that once she broke it off with you, you just kind of went away and left it alone. It's because you didn't. And you got, and what's concerning about you, other than this activity in and of itself, is you play around with drugs, if you have in the past. You've had domestic violence, multiple domestic violences in the past, and disorderly conducts and resisting arrest. So you don't seem to take direction very well.
Well, I've made a lot of changes in my life, Your Honor, and I have been sober for over 2 years now, and my life is going in the right direction, and I'm really working on it. I really am. I have a great job opportunity right now, and I really hope that that's able to happen.
Yeah, well, if that's going to succeed, then you probably should stop with the bullshit excuses of a butt dial, or I thought the order was up and somebody told me, and all that stuff, okay? Because, I mean, this is the shit that teenagers do.
I'm
It's,
sorry, Your
it's,
Honor.
it's, this is a stupid case. It's a stupid case that's entirely your fault because of the way you act,
You are
like a
correct.
17-year-old. That's what you were acting like. Anything else you want to say?
And I am sorry for everybody's time and trouble that I put them through with this. I apologize.
Well, the time and trouble doesn't matter, okay? The time and trouble matters to you, or it should matter to you. All the time you spent on this thing, and all the exposure you've had for yourself because of this stupid thing. That's
Yes, it's made a huge impact on my life.
Ms. Gold.
Thank you, Your Honor. It could not have been made clearer to the defendant that there was a protection order in place. He had just gotten out of jail for serving time for violating a protection order with the same victim when he left that voicemail and when he went to her house. Since this incident, the victim has gotten security cameras. The victim is not participating in violations of the protection order. She is afraid of the defendant and she wants the defendant out of her life. It is clear that the defendant has not learned from the time that he spent in jail for violating a protection order. And today he called these a mistake. These were not a mistake. These were a deliberate decision to go to the victim's house when he has a protection order, to walk up to her door. That is a deliberate decision that the defendant made.
This is where the defense tries to draw a neat little bow around a very messy history. You'll notice how carefully this argument is framed: better decisions, future plans, employment, and the magic phrase "it's in his head now." Courts hear this all the time, and it almost never carries the weight defense attorneys hope it will. Why? Because probation isn't about optimism, it's about trust. And trust is built on behavior, not promises. The defense wants the court to believe the lesson has already been learned, but everything in the record points the other direction. Protection orders don't exist for symbolic reasons. They exist because past behavior created real fear, and here's the key issue the defense can't escape: this isn't the first violation. Judges are willing to forgive mistakes. What they don't forgive is repetition. By the time this argument
Decided to undertake for the warped reasons you decided to undertake them, okay? All right, I've reviewed the pre-sentence report. I've listened to Mr. Henley and listened to counsel. I've considered all the provisions in 29, 29, 11, 12, and 13. I'm going to put you on community control for 5 years. I'm going to sentence you to 4 days in jail with credit for 4. I'm not going to put you in jail any more than what you've served before, okay? And the reason I'm doing that, before I get to the rest of the terms, that if you continue to screw around like this anymore, then you'll get credit for the 4 days when you serve 12 months in prison. Because we're not going to screw around with this shit. You understand that?
Yes, Your Honor.
Okay? You're to have no drugs or alcohol and you'll be screened. You're to have no contact of any type with the victim. That means you, that means anybody on your behalf. Okay? So if you're thinking of a way to contact her without contacting her, and you do that, and I find out you did it, then you'll go to prison for 12 months. You're to obtain and maintain full-time employment, and you're going to pay the costs and supervision fees of this case. And you're going to enter into and complete the decision points program through probation. Mr. Mr. Tompkins, anything else?
Just two things. We would just ask for mental health evaluation to follow recommendations. And then in regards to the GPS, is that coming off today?
Well, that was a condition of bond, right?
Correct.
Yes. Right?
Yeah.
Okay, yeah, the bond's going to be released. So I want you to get a mental health evaluation and follow all recommendations. You understand the terms?
Yes, Your Honor.
Any question about the terms?
No, Your Honor.
Okay, if you violate the terms, and the state will file a motion to terminate your community control, and if I find you violated, I'll send you to prison for 12 months. You understand that?
Yes, Your Honor.
Am I making myself perfectly clear?
You are.
Anything else, Ms. Gold?
No,
On the surface, this sounds like the moment we're supposed to feel sympathy. Apologies. Regret. Promises. But listen closely, there's a subtle but critical problem here. He keeps saying what won't happen again, but he never truly explains why it happened in the first place. Udges listen for ownership. Not just guilt, but understanding. Saying, "I'm sorry," doesn't mean much if it's followed by justifications, detours, and blame shifting. And Judge O'Donnell immediately zeroes in on that gap. Because without understanding the motivation, there's no reason to believe the behavior won't repeat. This is where many defendants lose the court without realizing it. They believe sincerity is enough. But sincerity without accountability sounds rehearsed.
764, defendant is present and represented by Nicole Novotny. Also, probation officer Nicole Newman is present. At our previous change of plea hearing on November 5th, 2024, the defendant pled guilty to count 1, F5, possession of cocaine, and count 2, F3, tampering with evidence. Court ordered referrals for pre-sentence report and drug and alcohol evaluation to be completed. Both have been completed. However, the defendant never signed releases forms for probation to receive said medical records, so there are substantial missing records about his substance use disorder treatment and activity. The state's position is that the defendant has 21 days of jail time credit, 2 days for his initial arrest, July 2nd, 2024, before his release on July 3rd, 2024, and then 19 days after he was rearrested on October 27th, 2024, and then released on November 14th, 2024.
After the 2 days, he was released when?
He was in jail July 2nd to July 3rd, 2024. Then he was arrested again on October 27th, 2024, and then released by this court on November 14th, 2024. So I think it's 19 plus 2 days for a total of 21 days.
Okay.
And there is no agreed sentencing recommendation, which is going to pass. Thank you.
Your Honor, when it comes to sentencing, we would ask the court to consider community control sanctions for my client. Ultimately, he considers this case in this circumstance as a blessing in disguise. He wants to take this negative and turn it into a positive. He really has had a trouble in his life, as you can see through the pre-sentence report, that he has trouble staying sober. He has taken initiative to try to stay sober by enrolling himself in Evolve. From my understanding, with speaking with the case manager there previously, Luke, and ultimately providing the court documentation prior, he has been with Evolve, from my understanding, since April 22nd of 2024. I do not, unfortunately, which I informed you in chambers, don't have an updated letter from Evolve. It has been very hard to get a hold of a case manager, unfortunately, with that respect. But with talking with my client, what happens, and for my last conversation with the case manager, they plan to restart the whole treatment process with Michael. Ultimately, they plan to start from square one. They also provide him with supportive housing, so he does stay and be a part of Evolve. They do provide him to transportation purposes, for court purposes, as well as what he has been doing with working. Michael has been involved with home improvement for the last 15 years. I actually had a conversation with his boss prior to coming into court today. He stated he would be here, but he has a job that he had to attend to, so unfortunately was unable to make it to court today, but states that Michael is trying to be on the straight path. He has been working constantly and maintaining his sobriety the best that he can with that respect, and wanted to be here today, but unfortunately, like I informed the court, due to his current job that he's on, he was unable to be here. He does have a sponsor, Michael does. He keeps in touch with that sponsor. Ultimately, he does go, and I know he has had some fluxes with going to his mental health provider at the centers, but he does have the centers as a support system for his mental health.
This explanation collapses almost immediately. The moment he admits he read the order, everything else becomes irrelevant. Courts don't care about rumors, phone calls, third parties, or what someone's friend supposedly said. Orders are not suggestions. They're instructions. What makes this worse is that he tries to justify calling the clerk's office instead of doing the one thing that actually matters, coming back to court. That choice alone shows poor judgment. And when combined with prior violations, it looks less like confusion and more like convenience. Judges don't punish people for being uncertain.